For those of you who weren't here, we are the ABI Consumer Commission. We aren't going to take up time with a lot of introductions. I'm Liz Paris, and I'm one of the co-chairs, and Bill Brown is the other co-chair. Bob Lawless is our reporter and timekeeper, and everybody else look in your materials for the introductions, because we don't want to take away from the panelists. So our first panelist will be Elizabeth Stevens.
Good afternoon. Thank you for inviting us to speak. A couple weeks ago, the Consumer Committee submitted a statement on student loans, not because we thought we had anything original to say or earth-shaking, but because our committee has practitioners of all different kinds. We have, debtors' attorneys, creditors' attorneys, we have trustees attorneys, and we all came to a consensus about the statement, and we thought that the Commission might be interested in that. We did spend a lot of time on history. I'm sure you have tons of material on the history, but I would like to start by addressing some takeaways that we should take away for the current situation. First, before 1976, student loans were fully dischargeable. I know you all know that, and in fact, I remember because I was paying off the student loans for my first career. So I remember that they eliminated the discharge in bankruptcy for student loans, but it didn't faze me because I was one of the 99.7% of student loan debtors who never tried to discharge the debt in bankruptcy. The fact is the student loans were made non-dischargeable in bankruptcy because there was a perception in Congress that people were using the bankruptcy system to eliminate student loan debt like immediately after graduation. Well, so the takeaway from that is what we need in the future is data, not perceptions. And they are still proposing legislation that's based on perception. We're not suggesting that striking 523A8 makes any sense. We believe that there should be a discrimination in favor of government student loans, because we need to ensure a supply of educated professionals and technical people, just like always, and we need to ensure that the loan benefit will be paid because it affects future generations. Now, on the other hand, the accepting debt for undue hardship was never addressed by Congress before it was made into law, and apparently it was the result of a compromise on the legislation. And so there was no guidance from Congress as to how to interpret undue hardship. The result was wildly differing interpretations among courts, which we see as really unfair, that the same debtors have no ability, or some debtors have no ability to discharge student loans at all. And the takeaway to that is if Congress amends 523A8, it needs to provide guidance. In our view, undue should be struck from the hardship test, and Congress should advise a totality of the circumstances test like the test the Eighth Circuit has devised. Third, we believe that 523A8 should not apply to private and for-profit education loans. No one seems to know where that BAP CPA provision came from. I would really be interested in hearing if any of you know where it came from. Most of the student loan fraud occurs in the private and for-profit context, and so there is a bill pending right now, and we would support striking or amending it to eliminate the private loan aspect. Richard Cole is going to talk about discharge of student loan debt in Chapter 13, which we think is a really important topic. One of the most interesting suggestions that came from our leadership committee came from an attorney who actually represents a student loan servicer. And he suggested that we should be looking into mediation as a possible way to affect some kind of relief for student loan debtors. And we haven't developed this idea very far, but it was suggested that either some sort of formal mediation program, kind of modeled on the mortgage mediation program, or, and I was listening to an earlier testimony, maybe this won't work, but it seems to me that a district court could just make mediation or a settlement conference mandatory for 523A8 actions. I guess the upshot to that would be a partial discharge of the student loan if it was successful. Other speakers have talked about access to justice. That is going to be a priority for our committee next year. At the spring meeting, we're going to be hosting a panel regarding more access to legal advice in the bankruptcy system. As I think about this and read more cases and reflect on my own situation, students who borrow money for education are really taking a big gamble. And this is not because I'm from Las Vegas, where we think of everything in those terms, but we encourage them to become educated and borrow money. We should be able to provide access to the bank for bankruptcy relief and take some of the burden off them for taking the risk they took.
Thank you. Next, we have Elizabeth Gunn.
Well, okay.
That's fine. Okay. Thank you for having me. I'm Elizabeth Gunn. I'm an Assistant Attorney General for the Commonwealth of Virginia, and I primarily focus on the enforcement of domestic support obligations in bankruptcy. I represent the Division of Child Support Enforcement. I also got the Tuesday afternoon phone call from Judge Wiedoff inviting me to enlighten you folks today, and then he took off.
So the lesson is don't answer the phone on Tuesday.
Well, yeah, exactly. Lesson is don't answer the phone on Tuesday. And then I traveled for the next 2 days, so I do not have written remarks prepared, but if the commission would like to, I'd prepare some afterwards. I don't have specific necessarily complaints as to domestic support. I go back to 1994 when they amended the bankruptcy code to add a bunch of protections for domestic support creditors. And if you look at the legislative history, those amendments were talking about allowing domestic support to continue on its way without much interference from the bankruptcy code. That was the theme. Let's not have any interference. But as we all know, it comes down to what actually happens in reality. And so I want to point out a few areas where maybe that carry through has not been what was envisioned. I'll start with the automatic stay and the exceptions that were added for collection of domestic support. It's been great that the modifications allow and clarified that paternity and domestic obligations and all of those can continue, those actions can continue. But the question is with the automatic stay exceptions for tax intercepts or for suspending licenses, when do those become property of the state? When do those become property of the debtor? When is a driver's license suspension post-petition a violation of the automatic stay without a motion for relief from stay, not because the automatic stay is property of the debtor, but because the funds garnered from the use of the license are property of the estate? And there's no clear answer. There's a split of authority, but I think most of the domestic support collection agencies, I don't speak on behalf of Virginia, just from my observations, I guess I need to say that, but most of them stop suspending licenses post-petition because they don't want to run into automatic stay issues. That doesn't mean they're reinstated, but there's an issue. Recently, my colleagues from the Florida Department of Revenue, who are their 4D enforcement agency, created a split of authority with respect to the automatic stay exceptions and what happens post-confirmation in a Chapter 13 case. What controls? Do those automatic stay exceptions continue after that confirmation, or is the agency bound by the confirmation order, particularly with respect to intercepts of taxes or other refunds that are automatically taken if the notification is put out that there are arrears? The First Circuit BAP ruled in an earlier case a few years ago that intercepts can continue, that they continue, they're not a violation of the confirmation order, and this was post-Espinoza if the confirmation order is silent. So confirmation order doesn't say one way or the other, but those exceptions continue. The 11th Circuit has gone the opposite direction and has said silence in their confirmation order means that you are prohibited from taking any collection to collect your arrears other than what's provided for in the plan. There was a petition for cert which was denied, but it remains an open question now. What can be done after confirmation of a 13 plan if the intent of the amendments was to allow collection to carry through the entirety of a 3 or 5 year plan, and yet now there's a confirmation order? I'll tell you, our agency in Virginia, we follow what's proposed in the plan, and unless the specifically states we can take the tax returns, we do not. But that's because that's a policy decision we've made. We don't have any authority in the Fourth Circuit. But there is an open question as to what happens after confirmation. A new interesting twist I've seen is the new form plan and the requirements for opt-out plans to have a separate section for 507A1B treatment, which are those priorities domestic support claims that are owed to the state. These are assigned if a custodial parent is receiving support for needy families. We are required to have an open case and collect and get some of that money back into the state. So that's required by the federal laws. In the new plan, it breaks it out. It says in paragraph 4.1 of the form plan, and of course opt-outs have these in various different places, but that they can be treated differently. But if you look at our proof of claim form 410, it only has one line for 507A1A and A1B. So unless the person filing that proof of claim, which we do, modifies their proof of claim in some way, there's no way to know which portion is an A1B that can be crammed down by the debtor throughout their confirmation. I'm sorry, there's a fly right here. Another interesting question is the new form plan says that all domestic support obligations must be paid. It has priority claims through the plan without interest. But if you go to section 101, 14A, the definition of domestic support obligation includes post-petition interest allowed under non-bankruptcy law. Virginia has a 6% per annum interest. North Carolina has 0 interest. So when you come to 1328 at the end of the case, and they have to certify they've paid all of their quote-unquote domestic support obligations due on or after the petition date, also before the petition date, does it include that interest that has been accepted in the plan but included in the definition? Sorry, a fly. There's always the continued issue of the exception of property settlements that are parading themselves as support, and that's usually where most of the reported cases come from. I don't deal with that a lot on an everyday basis, but it's what I hear the biggest complaint about, because domestic support lawyers are trying to get cute, and judges or they're trying to be educated and file it the right way, and I don't know if there should be a little more guidance about what is a domestic support obligation that is dischargeable in Chapter 13 as a property settlement or other item, and what is actually a domestic support obligation. The new 101.14a definition is so broad as the definition of domestic support obligation, and yet even very carefully crafted divorce decrees where they're clearly stating this lump sum is in exchange for consideration of payment of support that would have to be otherwise paid over time, are being discharged as property settlement. And so I'm not sure that that's giving the effect of the domestic orders what they should have gotten in the bankruptcy case itself. The other issue I have is the payment of pre-confirmation support in Chapter 13. We require a 1328 certificate to say that all support was paid prior to issuance of a discharge. However, debtors are required to pay all their post-confirmation payments until confirmation of the plan. And in some cases, that's 4, 6, 8, 9 months. That's the single most prevalent objection I file. And every time I file an objection, the first email I get from an attorney is said, my guy says it's coming out of his paycheck. And I say, well, or he's been paying it. And I say, here's the payment history. In the Eastern District of Virginia, they have a pre-confirmation certificate that's filed. And it's filed prior to the confirmation order being entered, which says they've made all of their post-petition support payments prior to confirmation of their plan. Again, allowing the process to go through without support creditors having to come in and run all the time. I guess the biggest point I can say is, as much as some of the other testimonies been today, people are debtors for a reason. They're usually behind on their domestic support for the same reason. They just don't pay attention to the details, or they think that the support agency can find them wherever they go. I love the call that says, well, you found me last time when I changed jobs. Why do you mean you didn't find me this time? And why do I have a $6,000 post-petition support default? You were supposed to be taking it out of my pay. Well, you didn't call and let the people know, and then you're not entitled to a discharge. I have taken discharges in the last few years for people who have a significant post-petition default, and they're not reviewing their pay stubs, and they file an inaccurate 1328 certificate. And I don't think maybe there's a way to fix the problem that debtors will always be debtors, but it sure would be nice to have some more affirmative statements as to what they're saying so that those individuals who aren't represented by a support agency are able to go through. I finally want to say, I do think that the trustee disclosure letters were helpful. We get probably no less than 25 phone calls a month. I guess my time is up. Sorry. Thank you.
You can finish.
Oh, thank you. I was just saying, we probably get no less than 25 phone calls a month from parents who have received their trustee disclosure letter saying, what does this mean? What does it mean that they've filed bankruptcy? And so thank you for referring them to the agencies. Even if we don't have an open case, I feel like it gives us an opportunity to educate them as to that. Are they the clearest letters? No. Perhaps there could be a suggested form letter because not all of them are the clearest language, and a lot of them send me calls and say, I didn't have a support obligation because you filed bankruptcy. Do I have a support case with you now? So that would be the only other suggestion was maybe some form language or suggested form language for those letters. Thank you so much for hearing from me.
Mr. Cole.
Hi, I'm Richard Cole from Cole & Cole Law, PA in Sarasota, Florida. I'm going to talk to you about treatment of student loans in Chapter 13 bankruptcy. As we know, 1322b1 incorporates Section 1122 into it, which basically forbids unfair discrimination between classes of claims, and student loans are generally treated as general unsecured debt, and so they shouldn't be treated any differently than credit card debt or other unsecured debts. Historically, this means that student lenders simply participate in the general unsecured claim pool in a Chapter 13 case. In the meantime, student loan debts are long-term non-dischargeable obligations. During the Chapter 13, they will continue to accrue interest at the bankruptcy interest rate, which means that many debtors under the historical model, where they just paid their Chapter 13 payment, will end up leaving bankruptcy with more debt than when they entered bankruptcy because the student loan will have grown in excess of what was actually discharged in their case. More recently, some Chapter 13 trustees in some courts are starting to maybe allow some separate classification of student loans under certain circumstances. For instance, if they are in a income-based or income contingent repayment, they might be able to continue to pay the student loan outside of the Chapter 13 plan. The student lender will not participate as a general unsecured creditor in those cases. This has happened in the Middle District of North Carolina. It is starting to happen in the Middle District of Florida. However, I think it's only a matter of time before some unsecured creditor objects to this treatment because many student loan payments are significant. I have a friend who pays over $2,100 a month in student loan payments, so if that were excluded from distribution to general unsecured creditors, they might get upset, and with the current composition of our Supreme Court and their strict interpretation of the Bankruptcy Code, I don't believe that they would allow this to continue if there was an objection by an unsecured creditor that got appealed to that level. So I think that is a problem that can be addressed with simple bankruptcy reform. First off, we could look at 1322 and allow student loans to be separately classified in a Chapter 13 plan. There might be conditions on that. Certainly, you may wish to force people into an income-based or income contingent repayment so that those payments are keyed to income rather than the standard payment. Sometimes that might be better for general unsecured creditors or worse, because sometimes an income contingent repayment could be higher than a standard repayment or it could be lower than a standard repayment. Another issue might be allowing the deduction of student loan debt in the means test under 707. Student loan debts are another long-term debt that survives the bankruptcy. All the other kinds of those debts are allowed as deductions in the means test, like home mortgages, cars, taxes, domestic support obligations. Those are all deductions. If it is allowed as a deduction under the means test, first off, we are easing the process for most debtors and making Chapter 13 more realistic relative to a debtor's actual financial condition in relation to student loans. So I think those are two simple things that can be changed to allow for student loans to go through the bankruptcy process with greater ease and allow debtors to have a better time reorganizing themselves without increasing debt as they go through 13s as they would have historically. I mean, otherwise, what do you tell them? If your disposable income means you can pay the payment, maybe you can pay the payment, but then your trustee might object or seek turnover of those payments because they were improperly made after confirmation if they're continuing to pay direct based out of their income. So that would definitely be a significant help, is if we could change some of those aspects, either 1322, but preferably I think both 1322 and 707, because I think it is a proper deduction from income, although it is not currently allowed since it's just a general unsecured debt. Just another issue I wanted to bring before the Commission. I'm sure you are all familiar with ProPublica's recent research into racial disparities in Chapter 13 bankruptcy that was also published in coordination with the Atlantic magazine. Those issues are obviously very complex, and they're obviously only recently researched, so I think the Commission does have a responsibility to look into why that problem is occurring. I know from my own practice, I believe that it is true. I get a lot of clients A lot of my clients come who have already filed for bankruptcy and are already in Chapter 13s and looking for alternative counsel or looking for counsel for the first time. And I can tell you that many of those people, that it is disproportionately people of color who are in 13s who probably didn't belong there in the first place. And so then we have to convert a case many years later. These people are coming in, they probably don't have a high degree of financial sophistication to begin with, and then they are misadvised or poorly advised by counsel in many situations. They don't understand what has happened to them. They don't understand why their case is being dismissed. They don't understand why property might be being repossessed. They don't understand the meaning of the discharge in many circumstances. So they don't know why they filed 13. Somebody just put them in there because there's more fees, maybe. I find it very upsetting when I see that. Obviously, it's an ethical issue. I think it's a problem as a debt relief agency to be filing people in 13 who would not properly be debtors under Chapter 13. So obviously, it is complex. How to solve these issues? It's obviously going to involve a lot of outreach and education, perhaps more so than actual changes to the code. But I think it's a serious issue that definitely needs to be addressed by ABI and the Commission. Thank you.
Questions?
Yeah, I've got a question about your proposal on the student loan.
Sure.
And the student loan classification. You mentioned 1322B1. Is it your suggestion that the classification that be done could pay less to the unsecured creditors than they would receive in a best interest of creditors test or a disposable income analysis?
Well,
or is that a threshold that they'd have to make anyway, and then you can do whatever you want with a student loan because it's reasonable and necessary?
Well, I think that's why also including student loans in the means test would be ideal, because it eliminates part of that issue, because then we don't have the income analysis affecting it as far as best interest of creditors test. I would say that 1122 probably should be amended to specifically allow student loans to be classified separately, and then we still would have the issues under liquidation analysis for other general unsecured creditors other than student lenders. They would still need to be entitled, I believe, to the liquidation value of the debtor in a 13.
Okay, but the lender is, student loan lender is in the same position. Don't you think it would work even under the separate classification if you have an adequate business reason for separately classifying, that if the combined total going to both the student loan lender under the plan and the other general unsecureds meets the best interest test, that would be enough?
Well, I think my position is that student loans are a different kind of debt, and they should be deemed a different kind of debt under the bankruptcy code.
Right, but if the proposal were to keep them but separately classify, wouldn't the combined student loan payments and the payments to the general unsecured classes independently, as long as they satisfy best interest, isn't that enough?
Well, it would certainly be good for deptors that way. I don't know if creditors would like that and would obviously probably lobby against that. Or it could be an issue that could be litigated, depending on how the code's drawn, it might be something that can be litigated and end up differently in different districts. She has an answer for you.
I just have a couple. I was telling him the answer is yes.
Okay. I just have a couple comments for this group. Thank you very much as a committee. I know you're a very vibrant committee to begin with, but to put your heads together and come up with some consensus proposals for us is much appreciated, so thank you for that work. Elizabeth, you made some suggestions about tweaking forms and so forth to make them fit better. I think you should also consider putting the suggestions up to the Rules Committee, because if it's just something that can be fixed with a tweak of a form, you'll probably have a faster result if you carve those things out and send those suggestions to the Rules Committee. And Richard, I just wanted to assure you that the issue that you raised regarding racial differences in filing is very much on our radar, and we are taking that quite seriously and have had some extended discussions regarding the exact issue. So I want to assure you that we're aware of that and we're discussing it.
Thank you.
If you find the answer to it, please tell us.
I wish that's what your job is.
I have a question on the student loan issue. First, thank you for that, for your statements. Do you have a sense of what the gravity of change would be if student loan dischargeability or the adjustments that you suggest were made? How many, in terms of dollars, what portion of student loan debt in default might be affected by these changes? How many borrowers out of the universe of student loan borrowers in default or forbearance right now would be able to reap the positive effects of this? I'm trying to get a sense of what the systemic impact of this might be in your estimation.
Yeah, I don't know the answer to that, but I think that's the kind of information that we need to make the decisions.
I think one of the problems to getting that information is that there's been such, one, a cost to challenging dischargeability of debt that many counsel have not brought it because the debtors couldn't afford the litigation, and two, because of the prevalence of the Butner test, or not the the Brunner test, sorry. The Brunner test in so many jurisdictions, debtors' counsel have just plainly told their debtors it's a lost cause. And so I think one of the reasons that we don't have a good idea of that number is because we have people who are just not even considering bringing those actions at all. There is an attorney who gave a presentation a couple weeks ago I saw who has a list of every single student loan dischargeability debt case that has been brought. And I was surprised at how small the numbers were, and I think that is evidence of those two issues. One, it's so expensive to bring it that these folks who can barely pay the $2,000 to $4,000 of filing fee can't afford the $10,000 to bring the student loan dischargeability action. And two, when I was in private practice filing for debtors, we just told them it wasn't possible. The Fourth Circuit, unless you were eating ramen in a darkened room and didn't have a cell phone, you shouldn't even bother trying. And so I just think people they don't know. They don't bring them, so we don't know.
And I think a lot of people who have problems with their student lenders don't come to bankruptcy attorneys in the first place because they just don't think there's an answer there, because they hear again and again it's non-dischargeable and there's nothing there for you. They're hiding.
But I guess my thought is there is a lot of data out there, so maybe if you defined, the issue in a certain way, you could collect some data that would indicate, the effectiveness.
Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you.
Is Mr. Hammonds in the room? Oh.
Does that work?
Judge Harwood.
Good afternoon. I'm Bruce Harwood. I am the chief judge in a one-judge district.
Congratulations.
Thank you. And I'll be the chief judge in a one-judge district for a long time because we're just a one-judge district. New Hampshire, that is. So, and I was feeling kind of special Tuesday when I got this call from Judge Wiedoff. I thought, wow, he cares about what I might have to say. My self-image, like meteorically, shot up for about 30 seconds. But I am very pleased to be able to be here this afternoon because I've only been a judge for about 4.5 years, and I came from a commercial background. So much about consumer law is new to me. But one thing that you could always fix in a Chapter 11 case was if somebody needed more time to do something that was generally possible to find a way to do that. So I'd like to talk today about one of the dead ends that I have encountered in my short career as a judge, which is the 60-month hard stop plan duration issue in Chapter 13s. The problem, obviously, excuse me, is that late in a plan term, issues might arise rendering completion of payments either difficult or impossible by month 60, but nonetheless the debtors might be able to, and in fact would affirmatively state that they could cure the default and fully perform the plan with just another few months, maybe even longer, maybe shorter. But there are no fewer than 3 bankruptcy code sections that seem to prohibit a plan from ever running longer than 60 months, 5 years. 1322 D1 and 2, which provide that the court may not approve payments over a period that is longer than 5 years. Pretty straightforward. 1325 B4A Romanette 2, which actually provides that the applicable commitment period shall be not less than 5 years for above median debtors anyway, but which I've come to understand actually means that it can't be longer than 5 years. And 1329C, which prohibits the court from approving a payment period that expires after 5 years after the first payment is due under the originally confirmed plan. And as an aside, and the commission hopefully will have a chance to maybe clean up some of the drafting issues that we live with, there's a split of authority on when the 5-year period actually commences. Some courts, including the only circuit court to address the issue, hold the period commences on the date the first the first post-confirmation plan payment is due. Others, and I think this is the better view, hold that the period runs from the first date that a debtor is required to make a plan payment, regardless of when the plan or any amended plan is confirmed. The Evans case from Southern District of Georgia. And I'll submit this in writing so you get the cites, but I tried to put this together quickly. So the commission might consider clarifying in the statute when the payment period actually begins to run, because I think that would clear up some uncertainty, and clearing up uncertainty is usually a good thing in statutory practice. But in any event, as I said, 5 years is a long time. Many things can happen and do happen during the course of a confirmed plan that can affect the debtor's ability to maintain current payments. They lose their job, there's an employment interruption, their mortgage payments increase significantly, unexpectedly. I saw one case where the Chapter 13 trustee's administrative fee actually went up, which rendered the plan underfunded. And most of the time, those things will happen in a way or at a time to give the debtor a chance to modify the plan under 1329 and still live within the 5-year period. But if they arise too late in the 5-year period, then given the 5-year limitations, there just may be nothing that anybody can do. And there are courts that hold that the 5-year limitation is a hard stop, drop dead date. So if you can't get something done beyond 5 years, then there's really no other choice other than to dismiss or convert. The courts that do rely on the absence of a statutory provision permitting the extension of the 5-year term see sort of a risk of a slippery slope. Well, if we go 1 month out, if we go 2 months out, then all of a sudden it's going to be 1 year out, 10 years out. What's too long? And I found it interesting that in the legislative history, there was at least some, I've just lost my place here, but there was some congressional intent that 5 years was actually debtor-friendly, that the idea was to prevent involuntary servitude, essentially, and so a plan couldn't last more than 5 years. That would be in the debtor's interest. But if a debtor finds him or herself at the end of a plan term and needs 4 months, 5 months, whatever, to actually get the benefit of the last 5 years' worth of plan payments, it would be useful for a court to be able to say that either there's an exceptional circumstances exception or there's some way to accommodate a debtor, particularly where in a case where the Chapter 13 trustee assents, where all the creditors either don't care or assent, and where it's the debtor themselves who are proposing to go beyond the 5-year period. Because if the 5-year period is there to protect debtors, then debtors ought to be able to waive the benefit of that protection on a knowing basis and not risk losing the entire benefit of their track record and of the previous 5 years in actually coming out of the Chapter 13 with a Chapter 13 discharge. Yes, they have an option to convert to a Chapter 7 and get a discharge anyway, but converting to a Chapter 7 might put their house in jeopardy, and as we all know, saving the house is one of the primary objectives that people try to achieve when they file a Chapter 13 case. There is one circuit-level opinion that was issued this year that approved of a framework for going outside the 60-month period, Chauvin versus Class. And so there is and I'll submit this with my written comments. There's a framework of 7-factor test to try to evaluate whether it makes sense for a bankruptcy court to extend the period. You know, how big is the deficit? What was the debtor's track record? Do creditors consent, et cetera? But for those courts who say, I'm sorry, plain language is plain language, and 60-month limitation or maximum is a 60-month maximum, then the class case and cases like it won't be of any comfort or use to a debtor who might otherwise still be able to get the benefit of a Chapter 13 discharge, where the Chapter 13 trustee consents, the creditors either do consent or don't care, and just a little extra time will get them across the finish line. So that is a dead end that I have encountered in my period as a judge so far, and to the extent that the Commission can think about eliminating dead ends, or at least eliminating ambiguities in the statute, I think it would be welcomed, at least on my side of the table. Thank you.
Thank you. Mr. Cooney.
Yes, thank you. I'm David Cooney. Thank you for permitting me to address the Commission. I believe the Commission is doing extremely important work. In fact, I teach bankruptcy law at Georgetown Law School, mostly commercial. I used to tell them that I thought bankruptcy was at the epicenter of the universe. I actually now believe consumer bankruptcy law probably is the most important body of law that concerns us today. And I think in my more grandiose moments, I tell my students that the mark of a civilization is how they treat their debtors, and their consumer debtors in particular. So I think this Commission is of almost limitless importance in my own mind. So my topic today deals with an issue that affects thousands of the 250,000 people that file for Chapter 13. And the issue is really this: may a Chapter 13 debtor exclude from the calculation of his or her projected disposable income those amounts that they propose to contribute to a qualified retirement plan, such as a 401k plan? I think the answer in the code is straightforward, yes, and it's found in plain language, in my view, in 541B7. But there's a significant disagreement over that relevant code provision. There is, in my view, an unfortunate decision from the Sixth Circuit that goes the other way, and therefore I'm going to, by the end of my talk, I'm going to suggest a statutory fix, or perhaps there'll be a resolution by the Supreme Court. By way of full disclosure, I do want to say that I'm currently litigating this issue in front of the Fourth Circuit, and I also need to disclose, I guess, that the U.S. trustee is on the other side of this case. So I am a partisan. So as you know, the goal of a Chapter 13 plan is to propose a confirmable plan, usually over a 5-year period, and 1325 provides that if the U.S. trustee or a creditor objects, then the debtor must devote all of his or her disposable income over the applicable commitment period to repaying creditors. Now, initially, the code said little or nothing about whether voluntary contributions to a qualified pension plan should be excluded from projected disposable income. That was changed in 2005 in BAPSIPA, and that really is the focus of what I want to talk about. So first, Congress amended 541B7, which now states that property of the estate does not include any amount withheld by an employer from the wages of employees for payment as contributions to a qualified plan. And the same change was made with respect to amounts received by an employer for contributions to a qualified plan. In addition, and here is really the key, Congress added the two well-known and hanging paragraphs, each of which says the following: except that such amount under this paragraph shall not constitute disposable income as defined in 1325B2. That was the provision that was intended, in my view, to make it clear that when debtors propose a Chapter 13 plan, they can make the lawful permitted amount of contribution to their retirement and not have that included in what is considered to be disposable income. I think Congress was clear about that. They wanted both debt repayments of loans to the pension plan to be excluded, and they wanted the contributions to be excluded. I think the language is clear. Now, unfortunately, what has happened, and the reason we need a statutory fix, is there have now grown up 3 well-recognized divergent views on what this plain language means. Initially, starting in 2006, just 1 year after BAPSIPA, the case of In re Johnson held the language was plain, and that it means exactly what it says, that voluntary contributions are not included in the calculation of disposable income and therefore a debtor can propose a plan to continue to make those contributions and not have it included as part of the disposable income. 10 bankruptcy courts in 10 circuits now acknowledge this is the correct rule and this is the majority rule. The problem is that a divergent body of law grew up out of the Sixth Circuit decision in a case called In re Seifert. And Seifert had two really profoundly different outcomes, one at the BAP level and one at the circuit court level. Now in 2010, the BAP said, well, here's the way we read 541b7. We think it means, and I will comment, they are adding a gloss that is nowhere in the code, that if a debtor is making contributions as of the petition date, they can continue to do so. And the focus was, what were you doing on the date of the petition? And the problem with that is not only is there not a word in the code to suggest that, but if you're unemployed and you're making no contributions, you're excluded from starting after you start your 5-year plan. And if you're making debt repayments to your pension plan, you're typically suspended from making contributions. So we would have excluded a whole class of debtors so that only well-off Chapter 13 debtors would get the benefit of the 541b7 exclusion. The BAP decision was then appealed to the Sixth Circuit, and the Sixth Circuit adopted a more stringent rule. And the Sixth Circuit said, we don't think any contributions can be made. And we translate 541b7 as meaning, and these are almost the words verbatim, only the contributions in the hands of the employer on the petition date are excluded from the calculation of projected disposable income. So you can make contributions if you want, but they're not excluded from the calculation of disposable income. That's the Sixth Circuit decision, and to my knowledge, although I know the U.S. Trustee's Office disagrees with this, not another circuit in the U.S. has adopted or followed the Seifert decision. All right, so this case got to the Fourth Circuit via Judge Kenney sitting in Alexandria by the pro bono matter that we represent. It's the case of In re COM2, and Mr. COM2 worked for the Department of Homeland Security. He was a border agent, and he had been making contributions for 15 years. His right to make contributions was suspended, and then he tried to propose a plan where he would make contributions. The U.S. trustee objected. Judge Kenney adopted the Johnson rule. The district court affirmed, and that case is now at the Fourth Circuit. It's been argued and ready for decision. I would like to suggest the following statutory fix. If you look at the Seifert decision and you ask what made them go off in the other direction, they looked at 1322F, which is the provision that says if you're making loan repayments on a pension plan, those are excluded from disposable income. But they said the 541b7 exclusion is not in Chapter 13. And they said Congress must have had a reason for having similar language, but in Chapter 5 and not in Chapter 13. I believe the Seifert rule would fall if Congress would move that 541b7 hanging paragraph into 1322. What can go in a plan? It would clarify the purportedly ambiguous language and now make clear that Congress intended to exclude both loan repayments and contributions to the voluntary plan.
Last, Mr. Hammonds.
Thank you very much. My name is Chad Hammonds. I'm a partner with the Jackson, Mississippi office of Jones Walker, LLP, which is a regional firm headquartered in New Orleans, Louisiana. I'm board certified in creditors' rights law. And as I told Professor Lawless and Judge Weedoff when I was contacted as a creditors' rights lawyer, I don't claim any special expertise in consumer bankruptcy because in Mississippi at least, with what I do, it's practice more of a, you might say, a mile wide and a foot deep. There's a lot of commercial work, some consumer work, state court collection, various things. And so to be honest, I was somewhat hesitant at first about accepting the invitation to speak because, again, I do not hold myself out as a specialist in consumer bankruptcy. I do some consumer bankruptcies from time to time. In fact, used to do more than I do now. But after speaking with Judge Weedoff, he thought that that I might have something to say that the committee might find interesting. So With that in mind, my comments are more of a general nature, and I think you'll detect some themes here based on what I have to say, based on what previous panelists have already said. I will say one thing in terms of my creditors' practice, and I will offer up one example for something that I guess people in the creditors' world would expect me to at least tote the water somewhat on the creditor side, is that in doing work for personal property leasing companies, which sometimes get a bad reputation, but they do serve an economic function. These are companies like Aaron's Rents, Rent-A-Center, and similar companies. The leasehold transactions that are involved when people go in to lease furniture, to lease washing machines and things like that, are defined, at least in Mississippi, as true leases. They are not defined as finance agreements. However, by default, many debtors' lawyers will list those as security agreements and will put them in their plan to be crammed down to value, and will also put them in their plans and will also file objections to secured claims. To me, those are facially, if not fraudulent, just manifestly incorrect, and they ought to know better based on simply who the identity of the leasing companies are. But what it does is force a company like Rent-A-Center or one of these other companies to pay a lawyer like me to go in to respond to an objection to secured claim and to object to confirmation of a Chapter 13 plan based on the proposed treatment of those leases as a security agreement. When you're talking about a lease that may be $2,500, by the time you pay a lawyer to go in and deal with that, the economic value of that transaction is gutted, and it frustrates those companies to no end. Now, I realize there's probably not a whole lot of sympathy out there in the world for those types of companies, but in any event, as I said, they do serve an economic function. A lot of people have no other recourse to be able to go and obtain furniture, to obtain appliances and things like that. So with that one example in mind, that's sort of the thrust of my comments on behalf of creditors. And what I'd like to now do is to shift to some more general comments based on what I, as a lawyer and as someone who thinks the bankruptcy system needs to work for people, based on those things, what I think the committee ought to take into mind and take into consideration. And I say that in part as someone, and one of the reasons I agreed to do this is as someone from Mississippi. As we all know, Mississippi is the poorest state in the nation. So any legislation, any rules, anything that is done to affect the consumer bankruptcy system will have a very distinct impact on Mississippi. We have a lot of poor people, a lot of people who file Chapter 13, a lot of people who file Chapter 7. Even though I'm a creditor's rights lawyer, and sometimes I make the joke, yeah, hard-hearted creditor's lawyer, my core sensibilities are to side with the people who have been beaten down by life and who have to go seek the services of friends of mine in the debtor's bar to help alleviate some of their financial distress. So I took the liberty of contacting representatives from the trustee world and from the debtor's world. I actually tried to contact a couple of people on the creditor side to solicit some input, but unfortunately I was not able to speak with anyone. But I spoke to a Chapter 13 trustee. I spoke to a gentleman who is a Chapter 7 trustee and who also does a lot of consumer debtors work. And I also spoke to the gentleman in Mississippi who files more consumer debtors cases than any other lawyer in the state, has a very thriving practice. Some of their comments are as follows, and again, I'll conclude with a general theme that they mentioned that I think you have already heard here today. The first gentleman I spoke with was Chapter 13 trustee, and he also happens to be a Chapter 12 trustee, a man named Harold Barkley, who's been doing this for over 40 years. Harold is one of the seasoned veterans of the Mississippi bankruptcy world. One of the first things he had to say is sort of in contrast to what the judge had to say with respect to 3-year and 5-year plans. Harold remarked that at least with the people he sees, in terms of 5-year plans, too many things happen over the course of 5 years. There's too much volatility in terms of job retention, divorces, and things like that. he said, just as a matter of percentages, people just cannot make a 5-year plan. If there was some way to try to compress and try to encourage 3-year plans as opposed to 5-year plans, that he thinks more of them could be viable. How that could be done, we don't know. These are simply observations, and unfortunately, we don't have any policy solutions at this point. The next 2 people I talked to, one man named Tilvester Goss, who as I said is a Chapter 7 trustee and a debtor's lawyer, mentioned that he simply thinks there needs to be more uniformity within the system. He and Harold both think that with the adoption of the Chapter 13 Uniform Plan, we probably will see that, and they hope to see how that plays out over the next year, and they are reasonably optimistic with respect to how the Uniform Plan will play out. The final gentleman I spoke with is a man named Tommy Ash, and I said he's a volume filer, a very good consumer debtors lawyer, and his comments also tracked comments by what Harold and Tilvester said. And again, I think you'll detect the theme here. Student loans. They said there's got to be something done with respect to the student loan issues that people face in bankruptcy. And all of them to a person said we're going to see more of it. I mean, Harold, one of them, Tommy Ash said it's killing people. And Harold Barkley, the Chapter 13 trustee, said that they just cannot deal with it. And uniformly, among the 3 people, they all said that was their foremost concern, was trying to find some way to deal with student loans within the context of the bankruptcy system. Now, I know one of the first panelists talked about the distinction between governmental loans and private loans and things like that. Some of the ideas were floated, maybe taking a harder look at student loans to unaccredited institutions and various things. Again, I know that there are mountains of policy issues that go into any consideration of what to do with student loans. You've got, what will happen to the lending markets. You also have against the backdrop of what you read in the press about colleges and universities and the rates of tuition climbing higher than the inflation rate over the past 3 decades. These things are all intertwined, and I think we recognize that. But again, to keep it just small bore, small gauge, focusing strictly on the bankruptcy aspects, again, there seems to be a common sentiment that I've heard here today and among the people I talked with, that student loans have to be addressed in some way or other, or it's going to be crippling not only just to individuals, but based on the number of individuals on a system-wide basis. So I'll cut my time short and yield the balance to any questions or further comments from anyone else.
Questions?
Judge Harwood, I agree with you that the genesis of the 60-month limit in Chapter 13 was a compromise by Congress trying to avoid the constitutional prohibition against involuntary servitude. And so there's a certain arbitrariness to the 60 months. And working on some way to extend that for a limited period may be a viable avenue for reform. Where I get concerned is when you're suggesting, well, make it 4 or 5 months or whatever. And
don't take me literally on that, okay?
We had a colleague who retired about 5 years before I went on the bench, and he was the Chapter 13 judge in Portland. He allowed unlimited suspensions of plan payments. That meant that 5 years after he was gone, when I took the bench, we were dealing with several hundred of his cases. There were 12, 15, 20 years long. People camping out in 13 after having these wondrous suspensions that he authorized. And we cleaned out a bunch of them because it basically said, the next miss, you're done. But it would be unfair, based on what they had, to throw people out who were making their plan payments religiously. So we lived with them till they got to year 20 or whatever, if they kept making the payments. But I don't see how that is a good policy result under the bankruptcy code.
Well, I guess my only point is that if there is no hope of getting beyond 60 months, then you're going to wind up having a few people who might otherwise easily have benefited frustrated. and I readily acknowledge that there is a risk of going too all of a sudden having every plan have exceptional circumstances that would extend it into 70 months or 75 months. I acknowledge all of that. But it seems, excuse me, even that if somebody gets that close to the finish line and the reasons that they can't cross it were either they're relatively unforeseeable or just simply late arising, that saying, sorry, 60 months is it, that might be a policy choice that everybody's got to live with. But, and I don't want to create a solution, or I wouldn't propose a solution that's worse than the problem that we're trying to address. I grant you that.
I mean, do you like the factor kind of test that's of a recent certain case on this, looking at multiple factors?
I think it can work. I think it can work. But if judges have no discretion to apply any factor test, then you don't even get to first base. So I'm just suggesting that either we should all accept the fact that we'll never get beyond 60 months, or if there is a way to, try to tailor some exceptions, to at least consider that that's a way to save some people from falling off a cliff and having to either convert or lose their house.
As a follow-up, Judge Harwood, thank you for your testimony. I heard you suggest a statutory change, 1322, 1325, and 1329. Is there also a best practice? I mean, I've had people who've played with the effective date of the plan, for example, knowing that they would need additional time in the beginning to actually extend the term and have it be 60 months from the effective date, or 60 months from confirmation rather than the commencement of payments. Are you making a suggestion that we come up with some type of at least observation on maybe a best practice that could be adopted by the courts?
Yes, thank you.
And will it be included in your paper? one judge jurisdiction, and you have a law clerk.
Judge, if every court adopted the class decision, would that solve the problem?
It could, except then somebody's going to say, well, where's the authority for a class to begin with?
In class, they didn't modify the plan. They just, which is what's prohibited. You can't confirm a plan that's longer than 60 months. It was lasting longer than 60 months. For whatever reason, your indefinite suspensions or whatever. Yeah. And it was just a question of, Judge, we want you to enforce this as you had said, like, the drop-dead guillotine date. And if you don't get finished by then, you're dead meat.
Well, it's the language in 1322 D1 and 2. It says the court may not approve payments over a period that's longer than 5 years. And then in 1329, in the context of a modified plan, prohibiting the court from approving a payment period that expires after 5 years after the first payment. So,
and if you never ask the court, it's never a problem.
Well, and that's what I seem to have experienced in New Hampshire, is that the trustee will let things go for a little while and see if the debtors can sort of limp over the line. And I'm not taking issue with that because it's working.
Well, in Nashville, the judge, when faced with that, said, I'm going to continue this hearing on the motion to dismiss for about a year. And we'll see what happens then. So,
yeah. Well, as I said, when you see a dead end or when you see a cliff, if there's something in the statute that could be tailored to not make it an unnecessary cliff, then at least it seems like an opportunity people ought to be thinking about.
Thank you very much.
Thank you.
Thank you.
And thank all of you for attending today.